Welcome to our seminar to launch a special edition of the Australian Journal of Asian Law on COVID and law in Asia. My name is Tim Lindsay. I'm Director of the Centre for Indonesian Law, Islam and Society, and I am one of the executive editors of the Australian Journal of Asian Law. The other executive editor of the journal and deputy director of our centre is Dr. Helen Pausacker, who is here with us today. Helen and I will be chairing this seminar. The seminar is going to be held in two sessions. The first session runs from now until about 5 o'clock, and we'll have a brief break before the second session, which runs through until 6 o'clock. We're lucky enough to have with us today authors of the articles in the special edition, and many thanks are due to all of them for giving up their time to join us today for this launch. And the guest editor of this special issue, Professor Ju Chong Tam, and I'll ask him to say a few words in a moment. Before we do that, a couple of notes about today's events. First of all, the speakers will all be given 15 minutes to speak, and they will speak in a panel of 3 speakers, with Ju Chong as the 4th speaker introducing the first session. And at the end of that, there will be a 5-minute period for questions before we take a break. And in the second half, we'll have another panel of 3 speakers with question time at the end. And I'd just like to flag to everybody in advance that if you have questions, please use the Q&A function, type your questions in there, and I will present them to the speakers, and Helen will present them in the second panel, which she'll be chairing. That's our arrangement today. I want to ask all speakers if they could please stick very closely to the time limit so that everybody is able to present in a timely fashion and we finish on time. COVID has had a devastating effect on communities across Asia, as it has, I think, on communities everywhere in the world. And that's why Helen and I felt it was important that we have a special issue dealing with the impact of COVID on laws and legal systems right across Asia. In doing that, we were lucky enough to win the support of Professor Ju Chong Tam, who, like us, is a part of the Melbourne Law School. And what I'd like to do now is call on Professor Ju Chong Tam to say a few words about the special issue before we go to our first speaker. So, Ju Chong, please.
Thank you so much.
I should just say, sorry, Ju Chong, I always do this. My apologies to everyone.
That's all good.
But before we start, I'd just like everybody who isn't speaking to please make sure your microphones are muted. Thanks again. And over to you, Ju Chong.
All right, no worries. Let me begin by acknowledging the traditional owners of the various lands upon which we meet. And a big thank you to both Tim and Helen for inviting me to be a guest editor for this edition. I think it's a wonderful privilege to be able to be a guest editor for this edition, to receive such really excellent, illuminating contributions for this whole range of authors from across the region. And also, it's been a big learning experience, one that I will value, working with both Helen and Tim. So big thanks to both of them. Mark Honigsbaum, in his book, The Pandemic Century, 100 Years of Panic, Hysteria, and Hubris, warns against taking what he calls a germ's eye view of pandemics. Now, his central thesis was that how pandemics are managed, their emergence, their evolution, and impact depend not just on epidemiological processes, reproduction rates, virulence, and so on and so forth, but profoundly on political, social, and economic processes. And indeed, in Victoria, the state of Victoria, Australia, where we're having a resurgence in terms of COVID cases, where the state government is refusing to impose any mandates on the basis of lockdown weariness. And some have speculated, very understandably, is less lockdown weariness as opposed to electoral survival. We see this point being underscored. And we see from this broader perspective, the significance of legal systems in pandemics, including the COVID-19 pandemic. Now, the guidance issued by the WHO makes this clear. Yeah, it talks about, to quote, all necessary public health and social measures to slow the spread of COVID-19. It speaks of administering COVID-19 vaccines. Now, both these sets of measures, public health and social measures, as well as administration of vaccines, would centrally include legal measures. And we see the OECD echoing this particular theme. In a publication entitled Regulatory Responses to the COVID-19 Pandemic in Southeast Asia, it said that the COVID-19 pandemic has underscored the need for well-designed, evidence-based, coordinated, and well-informed regulatory policy. Now, when we reflect upon the significance of legal systems and regulation pandemics, there's in fact a two-way relationship between the COVID-19 pandemic and the legal system. There's firstly the role of the legal system in the pandemic, including its effective management in terms of the spread and virulence and so on and so forth. And secondly, and going in the opposite direction, there's the impact of the pandemic on the legal system. So when we reflect upon the significance of the legal system in the pandemic, we need a dual focus. One that focuses on how the law shapes the responses and is itself shaped by the unfolding crisis. And this dual focus needs to be interactive. So for instance, attempts to improve the effectiveness of pandemic management can bring about fundamental changes in the legal system, notably in the states of emergency that suspend ordinary legal processes and principles, including constitutional norms. And we have a number of authors that will speak to that shortly. It's also a dynamic focus. From a germ's eye view, narrowly, there are different variants, and we know now about different subvariants, varying levels of infection, hospitalization, and mortality that affect both sides of the pandemic legal system equation. And the relationship is also wide-ranging. So take, for instance, the report on the International Center for Not-for-Profit Laws tracked on government responses to COVID-19 in Asia and the Pacific. And it only focuses on civic freedoms, but it lists 9 concerning areas, including some of the areas which will be touched upon by authors shortly: emergency measures, free expression and disinformation restrictions, increased harassment of vulnerable communities, and so on and so forth. And another example, the most comprehensive assessment of Asia's legal responses to the COVID-19 pandemic, COVID-19 in Asia, law and policy context, covers a broad compass, examining the first wave containment measures, including emergency powers, technology, science and expertise, politics, religion and governance, economy, climate, and sustainability. So we need a focus as interactive, dynamic, and wide-ranging. And it's my privilege to have edited this special issue, which seeks to add to the existing scholarship by providing insights into the complex and changing relationship between COVID-19 and legal systems through 8 case studies. I think it's a remarkable achievement. I sort of feel Tim, Helen, and all the authors that we have 8 case studies drawn from Asia: China, India, Indonesia, Japan, Myanmar, Timor-Leste, Vietnam, and also a Southeast Asian regional study. And when we look at these case studies, I think they point to 2 main dimensions of this relationship between the pandemic and legal systems: governance, firstly, and secondly, the substance and application of laws. Now, with governance, our first 2 speakers that are coming up will in fact deal with this particular theme. So we have the contribution on Indonesia by Ayun and Hofil, and I'll say very little about this because I'll leave it for them to talk about it. Oh, sorry, I got this wrong. I got it the other way around. Sorry about that. So they are the first speaker after the break. Yes, the first speaker for this particular session is the one on Myanmar. Lijibrat and Do will examine Myanmar's concurrent efforts to deal with both the COVID-19 pandemic and the national elections. And our second speaker in this particular session is on Vietnam, or the Vietnamese government's response to COVID-19 pandemic. And then in the session after 5 o'clock, we have the paper on Indonesia and also Susadi Kunha will speak about the new normal. His article is entitled New Normal Under the State Emergency in Timor-Leste. Now, the second dimension is substance and application of laws. And of course, governance and substance application of laws do not neatly divide, and there's clearly some overlap. Now, what we have as a third speaker in both halves of this particular event are going to focus on this particular theme. So the article by Yang, Godwin, and Steele, our colleagues Andrew Godwin and Stacey Steele, will focus on the role of the judiciary in COVID-19 pandemic in China. And then we have in the second half, again as a third speaker, and here's our regional study by Smith and Perry, tackling the vexed problem of fake news and its regulation. Let me conclude by saying this. As been said by many, the pandemic holds up a mirror to society. And what the articles in this special issue have shown is that the pandemic is truly a mirror to legal systems, highlighting their strengths and their limitations, and that in fact, it's a two-way mirror, with legal systems a prism through which the pandemic evolves and is experienced. Thank you so much.
Thank you very much, Ju Chong, for your introduction and opening for us all, and of course for your efforts in editing the special edition, which are much appreciated. And just a reminder to everybody here that the Australian Journal of Asian Law, we are always open to suggestions for new special issues. We've had special issues recently on law in Bangladesh, on LGBTQ rights across Asia, when we're working on special issues now on women in law in Asia. So if you have any suggestions, our focus at the Australian Journal of Asian Law is always on what you might call domestic laws of Asia, not international law or comparative law, but on the laws of the countries of Asia. And we're always open to suggestions. Thank you very much again, Ju Chong. We'll go now to our first panel, which is Jonathan Liljeblad. Sorry, after asking how I should pronounce your name, I got it wrong. Jonathan Liljeblad and Amado's paper on virulent pandemic and fragile democracy in Myanmar, complications of COVID-19 policies and the 2020 national election. Jonathan is from ANU, and you have 15 minutes. Thank you.
Hello, everyone. Thanks to Tim Lindsay and Helen Pausdacher and Ju Chong Tom for this project and for inviting me to speak today. I'm very grateful for the opportunity, and I'm very pleased to see the turnout and to see such a large interest in this particular topic. I'm going to preface my presentation today with just a number of comments. First is that this was actually a co-authored paper, and so I was working with another author. That particular author is in Myanmar now. And due to her situation, and which is in a state of extreme vulnerability, given the circumstances that have occurred since the military coup of February 2021, we elected to go ahead and use a pseudonym to protect her identity. So hence, what's on the paper is Amado, but I want to be clear, that's not the actual name, and that's a pseudonym just meant as a protective measure to try and reduce the risk to my co-author. The second thing I'll mention is that the paper itself deals with the year 2020, which was the convergence of COVID-19 and the Myanmar elections, and goes up to January 2021. It does not include the military coup, which occurred in February 1, 2021. We leave that as a direction for future research. And we're very full aware of the circumstances that have occurred since that time. But we left that out of the paper because, once again, the focus is on the impact of COVID on the elections at the time. And however, we do welcome any comments, and I'm certainly willing to go ahead and discuss on a speculative basis the circumstances that are going forward with regards to COVID and the conditions inside Myanmar. The last thing is that I'll note here is, I mentioned this to everyone before we started, I got off the plane just a few hours ago after 40-hour transit, so I'm doing my best to stay alert. But my apologies in advance, and do forgive me if I'm not as sharp as I might otherwise normally be. So to begin the presentation today, I don't have any PowerPoints. This is really meant to be more of a conversation, just to raise some of the issues and concerns that I and my co-author had. Essentially, we were working towards a point regarding the nature of politics in Myanmar, and some of the concerns we had about the approaches of the international community in regards to the conduct of the Myanmar elections in 2020, and specifically the implications or the complications of the November 2020 elections with respect to the potential return at that time was the potential return of the military junta, and it's very much been realized now. In essence, our fears very much came true. However, when we're talking about the Myanmar elections of 2020, which occurred in November 2020, it's not possible to talk about them without reference to COVID. COVID did have a major impact on the elections, and as a result of that, it filled out the substance of our paper. And so we ended up dealing with the conditions of COVID-19, the policy responses that were taken in response to COVID-19, the legal issues that arose out of that, and then as a consequence, the impact on the politics that arose out of the elections. I'll start by talking about the background regarding COVID in Myanmar in 2020. With respect to COVID-19 itself specifically, Myanmar actually came late to the COVID situation. It recorded its initial cases in March of 2020. It experienced a double wave. So there was an initial surge in April and May. There was a slight cessation in July, which led to a lifting of precautionary measures, which include lockdowns. And then there was a second wave that took off in September, October of 2020. And that second wave continued apace into November. As a result of that second wave, that the country undertook precautions with respect to COVID. And so these precautions were very similar to that seen here in Australia, as well as in other countries. So these included stay-at-home measures. It included an attempt to go ahead and begin delivery of vaccines. It also included additional measures with respect to the election. So the elections, the campaigns had started throughout the year, at the beginning of the year, but they had increased in August, September, and October of 2020. And then the penultimate period of time, of course, was the voting, which had occurred in November of 2020. In terms of how the COVID-19 protocols applied to the elections, there were two entities that were involved. There's a Ministry of Health and Sports. So they had the authority to go ahead and issue rules with respect to pandemics. And then you had the Union Election Commission, which had the authority to go ahead and issue rules and the conduct of the elections. With respect to COVID and the elections together, the two entities worked together to create something called the standard operating procedures. So that the standard operating procedures that came in a part 1 and a part 2. The part 1 dealt with the COVID protocols that applied to Myanmar's election campaigns, and part 2 dealt with COVID protocols with respect to the actual voting and polling in the campaigns. The second part I want to mention here is the nature of the protocols. For the most part, the protocols that were undertaken during the course of the election with respect to COVID were politically neutral, prima facie. They did not mention political parties. They did not mention particular individuals. They did not mention specific candidates. However, it was their implementation and the way that they were implemented that generated some issues. So in the paper, we itemized 4 specific ones that caused a bit of concern. The first one was that protocols involved the township by township stay-at-home orders. So basically, in certain townships where COVID cases were surging, stay-at-home orders were imposed. This meant that there was across the country in Myanmar, you had some townships that were under stay-at-home orders and other townships that were not under stay-at-home orders. This posed a bit of an issue with respect to political candidates. What this basically meant was that political candidates who had come from townships under stay-at-home orders were not allowed to campaign, whereas candidates that had come from townships that were not under stay-at-home orders were free to continue their campaigning. The other issue that cropped up was that if you were in a township that was under stay-at-home order, that effectively meant there was no campaigning happening inside that township. So it essentially preserved the status quo in terms of the public awareness of particular political candidates. And a result of that, it made it more difficult for challengers to go ahead and let themselves advertise or publicize their campaigns. The second concern that came up was that there were a number of areas of the country where voting was canceled altogether. So in particular, there were 15 townships where voting was completely canceled due to concerns for COVID. And there were an additional 41 townships in the country where there was partial closure of voting polls, again, due to concerns for COVID. This in and of itself was within the purview of the Ministry of Health and Sports and the Union Election Commission. But the location of these particular townships, if you look at them on a map, you would see that they were largely situated in minority areas of the country, particularly to the west and the east. And what this basically meant that you had a suppression of minority votes, and particularly any level of suppression of minority representation in a place like Myanmar is highly problematic, given the history of the country, in which minorities have always aired grievances regarding lack of representation, lack of self-determination, lack of influence in the country's politics, and to a large degree, minorities have maintained their concerns and have gone so far as to maintain ongoing conflict in the country ever since its independence. The third concern that we had came up with respect to the treatment of journalists. So journalists was considered to be non-essential workers, and as a result, they were placed under stay-at-home orders. However, the government news media was not bound by those orders. So this meant that government news media was able to go ahead and travel, whereas private news media, if they were attempting to go to a township that was under stay-at-home orders, could not travel to those places. The fourth point was the international travel ban. And this basically meant that there were no international observers to the election to monitor its status as a free and fair election. In addition, it also meant that international observers, if they wanted to have any kind of observation in Myanmar, had to work through local proxies. But given the internet issues, it was difficult to ensure adequate training, online training, on an equal basis throughout all parts of the country. Legally, all of these factors raise some questions, particularly referring to the Constitution. There is the right to participate in terms of citizens of the country having a right to vote, also having a right to be candidates. There's the right to free speech, assembly, and association. And then there's also a right to equality. All of these rights were impacted in some degree by the nature of the inequities or inequalities, I'll use that term, in terms that arose out of the COVID-19 protocols with respect to the election campaigns and the election polls. With the time remaining, I want to raise the political concerns that we have that came out of this. We are certainly cognizant of the legal issues that are associated with the COVID protocols with respect to the Myanmar elections of 2020. However, one of the things that we make it very clear to state in the conclusion or at the end of the paper is that there needed to be some measure of caution from the international community. There were two organizations in particular that were critical of the Myanmar elections. I shall not name them at this point in time, just leave them in the paper. And essentially the point that we make in the paper is that the military and its political party proxy, so the Union Solidarity and Development Party, or USDP, had criticized the elections as being unfair, and so that was a violation of international standards of being free and fair. They pointed to the COVID-19 protocols and the elections as evidence of the lack of free and fair elections. International observers, by stressing or highlighting the problems of the COVID-19 protocols and the elections, were unwittingly supporting the arguments of the military and the arguments of the USDP. As I and my co-author, we expressed in the paper that this effectively meant that you had international observers that had the good intentions to try and support democratization, and particularly the process of elections, but unfortunately had played into the hands of the military. Now, on an abstract level, this might have just been a coincidence, but it was very clear that by February 2021, that the military had been playing a very specific kind of a strategy to resume control over the country. And so as a result, the fears that I and my co-author had with respect to the military's ulterior motives had very much been realized. And so our fears are that international observers probably had lost the forest for the trees and had unwittingly played into the interests of the military to resume control over Myanmar. So for the future, a cautionary tale, or the cautionary point that we make, is that for situations like Myanmar, or for other countries that are similar to Myanmar, the international community needs to take a more holistic approach with respect to its comments or observations regarding COVID-19 protocols, to situations like the elections, or any other aspect of politics. In particular, I and my co-author finished the paper by asking the readers to try and take a broader consideration of the consequences of the COVID-19 protocols undertaken by any country, and to keep in mind the particular interests that are being served by the results of COVID-19 protocols with respect to politics. So I'm running out of time, so I'm going to go ahead and stop with my comments there, and I'm more than happy to answer any questions or facilitate any kind of discussion further on with the rest of this panel today. So thank you for your time.
Thank you very much, Jonathan, for finishing so precisely on time and kicking us off to a great start with that analysis of the impact of COVID, or rather its interaction with politics in Myanmar with tragic consequences. And also for doing it while severely jet lagged. You get the Medal of Honor. We move now from Myanmar to Vietnam. Next speakers, or our next authors, Zhao and Uk, their piece State of Emergency in Vietnamese Law, Reflections on the Government Response to the COVID-19 Pandemic, will be presented for them by Tan Ku Vu. All our authors and presenter are from the Vietnam National University, and we're grateful to them for their contribution to the journal. So thank you, Ku, for speaking on behalf of Zhao and Uk. Over to you. You have 15 minutes.
Thank you, Mr. Lindsay. Hi, everyone. So I am a student of these two professors. And first of all, I would like to convey greetings, thanks, and apologies from my two professors, because they have a certain meeting, so they cannot participate in this conference. I am very honored to be entrusted by them present this paper summary today. So the papers of Professor Zhao and Uk provides an insight from the Vietnamese government's response to the COVID-19 pandemic in relation to the constitutional mechanism of Vietnam vis-a-vis emergency powers. The part one discusses the provisions on emergency power under the Vietnamese constitution 2013, and the relevant legal documents. The part 2 analyzes the Vietnamese Prime Minister's directives to deal with the COVID-19 pandemic, which are legally overriding constitutional emergency powers. And the last one, part 3, explores the possible safeguards against the executive abuse of constitutional emergency powers in Vietnam before concluding with some remarks. So, as indicated by the authors in the part 1 of the paper, Vietnamese law regulated the issues of the state emergency right after the country got independence from the French colonial period, from the August 1945. So the first constitution of Vietnam, the 1946, did not provide a definition of a state of emergency, but implied one of the emergency states, which is on national defense and security, by entitling the government the power. So similar to the 1946 Constitution, the 1959 Constitution and the 1980 Constitution did not include a definition, but also contain a provision on the state of emergency on national defense and security. It was, however, not until the 1992 Constitution, the term state of emergency was officially stipulated, and emergency situations were more clearly defined. So subsequently, on March 23, 2000, the Standing Committee of the Vietnamese National Assembly issued an ordinance on the state of emergency to concretize what the 1992 Constitution provisions related to the state of emergency. So the Vietnam's current constitution in 2013 inherits the 1992 Constitution provision on the state of emergency, as it continues to stipulate that the National Assembly has a mandate to determine states of emergency, and the Standing Committee has power to declare or cancel a state of emergency in the whole country or in a particular locality, while the state president has power based on the resolutions of the Standing Committee to proclaim a state of emergency. So by giving legally supreme emergency power to the legislative branch, Vietnamese constitution makers prove that they still remain loyal to the socialist state model, in which the parliament plays a dominant role in the state apparatus. So regarding human rights issue, when an emergency occurs, the state needs to take measures to maintain public order. However, it also requires that the derogation of certain human rights and freedoms. So therefore, the Constitution should ensure a balance between maintaining public orders and pretending the abuse of emergency powers to violate human rights. So in that direction, the Article 14.2 of the current Constitution envisage the possibility of derogating human rights in an emergency, and at the same time establishing the condition for such derogation. In part 2 of the paper, the author demonstrated that in the context of the COVID-19 pandemic, in lieu of requesting the Standing Committee to declare a state of emergency as the constitutional requirements, in 2020, the Prime Minister of Vietnam issues a series of directives to deal with the situation, including the Directive No. 16, which actually applied human rights derogation without declaration of a state of emergency. So the questions are, why the Vietnamese government's abuse of emergency powers in response to the COVID-19 pandemic are not prevented, and also why the local people do not seek remedies for the violations of human rights resulting from those acts of the government. So in relating to the first question, according to the authors, it firstly stems from the urgency of the situation and the complexity of initiating legal proceedings on emergency powers in Vietnam. Secondly, it springs from the weakness of the monitoring mechanism of emergency power in Vietnam. So in a sense, the misuse of emergency power is a constitutional violation, but Vietnam does not have a clear and effective constitutionality review mechanism. Relating to the second question, as argued by the authors, it firstly comes from the incomplete provisions on human rights limitation in the current constitution. So in such a context, Vietnam seeks to eliminate substantive discussions on human rights protection in general and on human rights derogations in particular. Most Vietnamese people, therefore, do not know that there are human rights violations associated with the government countermeasures against the pandemic. So, and also from another perspective, although according to the Vietnam's administrative procedure, citizens can sue state agencies and public officials. But however, such lawsuits are often fruitless, partly due to the lack of independence of the court system from the Communist Party and other state agencies, which make the court often subject to the influence of the subjective of the executive branch. So the big question is now how to prevent the misuse of emergency powers in Vietnam. In this paper, we argue that that Vietnam should revise a number of legal documents, including the current constitution and the ordinance on the state of emergency, and also a lot of legal documents. The solutions are actually not too complicated, but there are many challenges to implement them in Vietnam. Because the current political system in Vietnam is the biggest challenge for any attempts to democratize the current mechanism to control power in general, power in a state of emergency in particular. So it also should be seen that in the context of the current one-party political system in Vietnam, and reforms with the mechanism of power control are only half-hearted and of limited effectiveness, because the Communist Party can intervene in that mechanism whenever it deems necessary. So in practice, a separate law on the state of emergency replacing the ordinance in 2000 is finally get out of the list of new laws to be drafted, both in 2020 and 2021. But like other law, this separate law on the state of emergency did not get adopted from the National Assembly. On the issue of constitutional reform, the possibility of initiating an amendment to the provisions of emergency powers in the current constitution is unlikely in short term, because although Vietnam applied a soft constitutional model in which the amending procedures are not complicated, the constitutional amendment in this country often requires institutional transformation. And from another angle, although the issues of constitutional rights protection and control of power are both essential in many countries, they are, however, in Vietnam, not seen as urgent needs in a socialist regime like Vietnam. On the contrary, they are considered sensitive issues because it is an obstacle in a party state to reform the current constitutional mechanism on emergency powers. So in short, although the government's response to the pandemic has deepened the need of reforming the constitutional and statutory mechanism for emergency powers in Vietnam, this had not been done and may not be carried out in a short run. It also means that the risk of the government misuse of emergency powers in Vietnam in the coming year is still high. So for the concluding remarks, in democratic countries, the misuse of constitutional emergency power is unlikely to happen because the government understands that the balance between protecting the public order and the public interest with the violation of human rights and human rights derogations needs to be conducted in a democracy. But in such a socialist country like Vietnam, we have a lot of principle that is, I think, very unique in comparison with another country. For example, constitutional instrumentalism. So through the COVID-19 pandemic, with the government response, we can see that in some sense, the emergency powers has become a constitutional mutation, in the sense that the directives from the ministers derogates and violate human rights, while he did not make a constitutional decision according to the current constitution. So in summary, regarding the misuse of emergency powers, the current situation in Vietnam is inconsistent with the judgment of Pedro de Vega, which states that the constitutional mutations can coexist with the principle of constitutional supremacy, without the latter suffering a significant deterrent. This is because, as analyzed earlier, the Vietnamese government has not faced the challenge of exceeding emergency powers, even though the constitutional supremacy has been violated. In the short term, this issue in Vietnam will not change either, because also according to Pedro de Vega, the problem of the limits of mutation only starts when the tension between the facts and the normativity turns socially, politically, and legally into a conflict that endangers the notion of supremacy itself. So contrasting with this statement, for many reasons, it is unlikely that the transgression of the government can turn into the political, social, or legal conflict in Vietnam when the government scores well with the local people and the international community on the fight against the pandemic at the early stage, and when the government action has implicit backing of the Communist Party. So thank you for listening. That is my presentation.
Thank you very much, Ku, for a very articulate summary of the paper, and thank you for presenting on behalf of the two authors, Professors Zhao and Uk. We're very grateful to you. Also grateful to you for finishing even earlier, before the deadline. So congratulations. Our next speakers take us north to China. The paper by Jung Yang, Andrew Godwin, and Stacey Steele on China's COVID-19 response, the role of bankruptcy law and typical cases, and that'll be presented by the first named author, Yang from Wuhan University Law School. So Yang, please, you have 15 minutes. Thank you.
Good afternoon, Tim, Helen, Catherine, and Cho Chang, and dear friends. Thanks very much for inviting me to participate in this meeting. I'm glad and honored to share some thoughts about our article on behalf of my co-authors, Andrew Godwin and Stacey Steele. The topic of our article is China's COVID-19 response, the role of bankruptcy law, and 8 typical cases. First, please let me share some data. In the first 4 months of 2020, 713 formal applications for bankruptcy procedures were filed in China. In particular, the number in April was 345, an increase of 143% year-on-year. The increased number of filings and the quick response of the Supreme Court in publishing typical cases suggested that COVID-19 could be a turning point for corporate bankruptcy law in China. A critical question here we explore in our paper is how these developments might influence bankruptcy practice into the future. Based on the above background, our article is organized into 3 parts. First, it provides an overview of the Chinese bankruptcy law framework and introduces the concept of typical cases. Secondly, we analyze China's response to COVID-19 and the role of Supreme People's Court, SPC, in providing guiding through 8 typical cases. Thirdly, we undertake a further analysis regarding how the courts in China play an active role in implementing corporate bankruptcy procedures to promote national consistency. Let's come to the first part. Overview of the Chinese bankruptcy law framework and case guidance. China's enterprise bankruptcy law was enacted in 2006, which makes it a relatively young law. Alongside the liquidation, it recognizes two formal court-supervised corporate rescue procedures, reorganization and compromise, each of which is pretty much similar to the procedures found in other jurisdictions. China's court system is unitary national court system that consists of 3,087 basic courts, 416 intermediate courts, and 33 higher courts, and of course, one Supreme People's Court. The Supreme People's Court is the highest judicial organ in China. The basic courts and intermediate courts in China have jurisdiction over bankruptcy cases. In recent years, the SPC has supported efforts to develop China's corporate bankruptcy law framework. At the beginning of 2019, the SPC began to approve the establishment of specialist bankrupt courts. There are 12 specialist courts at the time of writing in December 2020. It's worth noting that although China's legal system is civil or continental in design, it has actively explored the case guidance system. In 2010, the provisions concerning work on case guidance were published. The SPC examines case guidance in 3 categories of cases: guiding cases, typical cases, and general cases. Guiding cases, which are issued only by the SPC, have the greatest precedential value in terms of representing an indirect source of law. From the perspective of hierarchy, typical cases are located between the guiding cases and general cases. In other words, a typical case may demonstrate a particular trend, outcome, or technique that the issuing court expects lower courts to learn from, but these cases have not gained the precedential value of a guiding case. So comparatively speaking, typical cases have the advantage that they are relatively straightforward and quick to publish. Now let's come to the second part. Responses to the COVID-19 crisis, SPC's role and analysis of atypical cases. Given the history in China of selecting typical cases to provide guidance to lower courts and the rapid developments surrounding the COVID-19 outbreak, the publication of 8 typical cases in March 2020 was not surprising. The cases were published on the SPC's website under the heading Typical Cases of Civil and Commercial Matters Concerning the Resumption of Work and Production during the period of epidemic prevention and control. So as Table 1 shows, the typical cases were equally divided between primary level and intermediate level courts. The courts at these levels generally hears the largest number of proceedings relating to the EBL, enterprise bankruptcy law. The registration city of the relevant enterprise in the 8 typical cases indicates that 6 enterprises in the 8 typical cases were located in Eastern China. As we all know, China may be divided into 4 economic sectors: Eastern, Western, Central, and Northeastern. The Eastern area accounted for more than 50% of the whole China's GDP in 2020, of course now. The cases are also categorized by industry. Given the nature of the COVID-19 crisis, it is also not surprising that the products in the cases involved in the manufacture of masks, disinfects, medical substances, and other necessities for people's livelihoods. A guiding opinion issued later by the Supreme People's Court on 15 May 2020 highlights that the importance of managing bankruptcy procedures during the COVID-19 crisis. The guiding opinion instructs courts at all levels on how they should try civil cases involving contracts, finance, and bankruptcy. The guiding opinion has binding effect as a formal source of law. It has a total of 23 articles, of which 7 are related to bankruptcy cases. So let's come to the third part, further analysis of SPC's response to the COVID-19 and the use of bankruptcy law. More importantly, as discussed in our paper, these typical cases suggest that COVID-19 could be a turning point for bankruptcy law in China in relation to 5 key issues. First, the first key issue is the significance of the cases. The test of the typical cases demonstrates the Supreme People's Court selective publication of information about the typical cases in a case note style. First, the test provides a very brief outline of the facts of each case. Second, a didactic interpretation of the case, also known as the typical meaning, is presented. Thirdly, the 8 typical cases do not include identifying features such as case numbers or keywords. So this kind of, a trimmed down approach to information sharing indicates that the 8 typical cases are less about how the law should be applied and more about the role of the courts and the need for cooperation between the relevant stakeholders. And more interestingly, the timing of the publication of the 8 typical cases is also noteworthy. Compilations of cases in China are usually published in batches of, the number of 10, because this number is believed by many, in Chinese or maybe in Asian culture to be good fortune. 10 is a good fortune. And here the number we can say is 8, not 10, which to some extent shows that the Supreme People's Court of China are both very keen to publish guidances as soon as possible. The second key issue is the coordination role of the courts. The typical cases reinforce the active coordination role that the courts are expected to perform. This role includes guiding the work of insolvency administrators. Although insolvency administrators formally operate on an independent basis, they are appointed by the courts. In addition, the 8 typical cases suggest that the authority of the courts has increased relative to local governments. In case number 2, for example, the court is said to have coordinated with the local development and the reform commission to sort out the company's debt problems. The third key issue here is the flexible application of enterprise bankruptcy law. The Supreme People's Court's endorsement of the willingness of the courts to reopen existing agreement between stakeholders in insolvency proceedings is very clear. Half of 8 cases involved companies with existing agreements. The fourth key issue is the focus on reorganization. Of the 8 cases, 7 avoided liquidation and adopted reorganization-based measures. The preference for rescuing these financially distressed companies is clear. The focus on reorganization is consistent with a fundamental assumption that it was necessary to rescue these companies in the context of the COVID-19 crisis. The fifth key issue here is the continuing importance of social stability as a paramount objective. This objective is reflected in the preamble to the guiding opinion issued in March 2020, which refers to the need to implement the so-called 6 stabilities work and to achieve the task of the so-called 6 guarantees. This finding is also reflected in the name of the batch of the atypical bankruptcy cases named typical cases of civil and commercial matters concerning the resumption of work and production during the period of epidemic prevention and control. So China has adopted various measures during the COVID-19 crisis to mitigate the effects of the crisis on enterprise bankruptcies. This analysis of the atypical cases and the guiding opinion in this article suggests that this measure have been driven largely by the courts, and also suggests that COVID-19 has provided courts with a platform to dominate proceedings that may have a lasting impact on Chinese bankruptcy law and practice. So that's my presentation. Many thanks for your attention. I'm looking forward very much to attending the next event with all of you in person. Thank you.
Thank you very much, Young.
Yeah.
Thanks again for being willing to present on behalf of your co-authors. We now have a short period for questions before we take a break and return for our second panel. So if you have questions for any of the speakers, please could you just enter them in the Q&A function, which you see along the bottom of your screen, and we will pass the questions on to the speakers. While I'm waiting for you to send us some questions, we don't seem to have any right at the moment, I'd like to put one myself to Jonathan. Quick slurp of coffee required, Jonathan, I think, in your jet lag state. And because I am going to put you on the spot a little bit, which is in relation to your paper, which looked at the sort of unfortunate coincidence of COVID and the difficulties in the way in which the problems in the election were presented, perhaps somewhat unaware of the difficulties they were creating by international media and election monitors. Then the coup followed. And I was wondering if you had any comments you'd like to make in addition to your paper and your presentation about the relationship between the events that followed the coup, the nature of the regime, and COVID.
Yeah. Yeah, and thanks for the opportunity for me to answer that particular aspect. Yeah, because in some ways that's even more significant than what occurred during the election. So after the coup, for those of you in the audience who don't know, after the coup, there was a nationwide uprising by the mass populace. And so this included a civil disobedience movement that covered all levels of government throughout all ministries. So this is quite a significant event in the country's history. And outside of the civil disobedience by the government workers, there were mass protests in the streets, again, throughout all of the areas of the country. And a resumption of violence by some of the ethnic armed organizations, as well as what are called People's Defense Forces in urban areas against the military. In response to that, and so this is where the COVID-19 protocols come into play. The military has been engaged in a campaign of suppression. It's just a matter, they don't want to engage. The military's perspective is that this is a pacification campaign. So anything that furthers the process of pacification becomes an instrument of military of activities. So part of that is the COVID-19 protocols, where it's the rules that were put into place regarding stay-at-home orders, regarding the suppression of people out in the streets, regarding the restriction of travel. These all furthered military control. The other components that most of the international community is not aware of also is that medical services became weaponized, so that medical services became an instrument of military control. So the military basically is able to control import or export of medicines, of medical equipment, of medical expertise. This includes vaccines. And this basically means that they are able to then direct the relevant COVID-19 medical services to loyalists and away from anyone it deems it's part of its resistance. So this is a clear example of this with respect to the vaccines, which are being, I won't use the word hoarded, but they were being aimed primarily at members of the military, and they were being denied to the larger population. They were also control of oxygen. So the oxygen was being reserved for the military and military loyalists, and they were being restricted from the larger population. The third thing I'll mention with respect to COVID protocols is that the doctors, the medical doctors in Myanmar, were at the forefront of the uprising against the Myanmar military. The medical doctors basically protested by saying that they refused to provide medical services to members of the military or to anyone who was in support of the military. All of the Hippocratic Oath issues aside, what happened is that this made them a target of the military, and so you have seen arrests by the military of medical doctors, and so this has made a weak health system even weaker. And it has also meant that there's been a denial of medical services for the larger population. And so, incidentally, this isn't with respect to just COVID. There are collateral impacts of this. So I can tell everyone from personal experience. In my family, I've had some relatives who recently died of cancer in Myanmar. While their conditions may have been terminal, we can definitely say that their deaths were accelerated because they were not allowed to seek medical treatment due to the military's activities. And so since the coup, basically, it's a situation where COVID and the medical services attached to it have become very much instruments of military control. So, yeah.
Great. Well, thank you so much for that update. It's fascinating and disturbing at the same time, I'm afraid. Okay, there's still no other questions in the question function, which I think we have to take as complete consumer satisfaction, maybe even enthusiasm. I just wanted to ask, we have time for one last quick question. Does anyone on the panel wish to ask a question of anybody else on the panel? Okay, I'm taking that as another demonstration of complete satisfaction in the presentations, which have been excellent. Thank you very much, everyone. 2 points to make before we have a quick break. First is we have a special issue coming up in preparation at the moment on the death penalty in Asia. And if you or any of your colleagues might be interested in submitting a paper for that or suggesting a theme you might want to address, please let Helen and I know so we can discuss the suitability. We look forward to hearing from you. And next we go to a break for 5 minutes. We're going to come back at 5:10 punctually, exactly, please, so that we don't lose time from the first presenter's time allocation. And I want to ask all the speakers in the first session, obviously thanking you all very much, but asking you, please, can you come back after the break to support the speakers in the second section? I'd also like to finish by thanking the staff in our centre, and in particular Catherine Taylor, for their work making the seminar possible. So I'll just hand over now to Helen, who'll open up the next session, and I'll see you all back in 5 minutes exactly at 5:10. Thank you.
So it's my pleasure to be the moderator for the next 3 speakers. And the first of these will be Rafika Kurata Ayun and Abdul Mugis Mudofir, who are going to speak on Indonesia. Rafika is from the University of Indonesia, but we also have the pleasure of having her in the Faculty of Law at the Melbourne Law School at the moment. And Mugis is from the Department of Sociology from the State University of Jakarta, and he's with the Asia Institute at the University of Melbourne. And so Rafika is going to speak on behalf of both of the authors. So I'll hand over to you, Rafika. Thank you very much.
Thank you, Helen. Good afternoon, everyone. Thank you SILIS and ALC, especially Professor Tim Lindsay and Professor Ju Chong Tham and Dr. Helen Klosacker for inviting us to this presentation. It's an honor for us to be here with all of you discussing law in relation to the COVID-19 pandemic handling. I'm Rafika from the University of Indonesia and Melbourne Law School, and I would like to present the research paper I wrote with Abdul Mughis Mudofir from the Asia Institute, University of Melbourne. This presentation is based on our article that has been published in the Australian Journal of Asian Law. The title is Reproduced as Indonesia's Liberal Legalism Amid COVID-19, Public Health Crisis as a Means of Accumulation. Some illustrations I used in this presentation are photos of street art from different regions in Indonesia, protesting the COVID's handling and contentious laws issued during the pandemic. So our research seeks to explain a particular feature of legal and political system that help to understand the extent to which a country has controlled the pandemic, and at the same time protect the rights of its citizens. During 2020 to 2021, many reports indicate that some countries have been relatively successful in containing the virus, but by violating citizens' rights, as seen from how state surveillance has been deepened and extended. This trend appears in some countries like China, Vietnam, and Singapore. Other autocratic countries like Iran failed in controlling the pandemic and, of course, in protecting rights. During that period, some democracies like South Korea, Taiwan, New Zealand have been considered as relatively successful both in containing the virus and protecting rights. But in Sweden, for example, the number of cases was high compared to other Scandinavian countries. Its mortality rate is also high, which was claimed as the result of the attempt to protect the rights of the citizens by not undertaking lockdown measures. In illiberal democracies like Indonesia, the Philippines, India, Brazil, Hungary, and United States, the government has failed at both controlling the pandemic and protecting rights. And by focusing on the Indonesian case, our research tried to understand this phenomena. At the same period in Indonesia, many studies, reports, and credible mass media recorded the messy handling of COVID-19 pandemic in the country. Since the first case confirmed in March 2020 until July 2021, when Indonesia became one of the global epicenters for COVID-19, many reports have shown that Indonesia's handling of the pandemic is the worst in Southeast Asia. More importantly, as the government was less transparent in reporting the cases, it is very likely that the real number of cases during that period was higher than that of officially reported. The mortality rate of the health workers was also among the highest in the world. Meanwhile, testing rate in Indonesia was also among the lowest during that time. In the lockdown, known as the Emergency Public Activity Restriction, or Pemberlakuan Pembatasan Kegiatan Masyarakat Darurat, or PPKM Darurat, from 3 to 25 July 2021 in Java and Bali, was not accompanied by a sufficient social safety net. While the lockdown has suppressed public dissent, executive and legislative assemblies continue to deliberate contention laws. The question is, how do we explain Indonesia's poor handling of the COVID-19 pandemic and worsening protections of human rights? Many scholars have also attempted to answer the similar questions. Most of them attribute the lack of success in containing the virus to inadequate resources and weak institutional capacity. Scholars like Mitzner, for example, argues that the government's poor response is a result of Indonesia's democratic deteriorations in the last decade, which has eroded the capacity of the government to effectively address the outbreak. These studies are certainly important, but we think that they only superficially explain the main problems by emphasizing on government's institutional capacity. This is to say that the failure in dealing with the pandemic and violation against rights in Indonesia is not simply because the government has no capacity or that because the President Joko Widodo or Jokowi has no leadership. What is seen as the government's incapacity, lack of coordination, and weak institutional and leadership capacity are a result of the absence of interest in containing the virus. Why? We argue in this paper that Indonesian experience of COVID handling underlines the illiberal nature of politics, where the rule of law is relatively absent, government accountability is low, and rent-seeking is pervasive. This has made the public health crisis being seen as a means of accumulations, exploited for illiberal purposes, and leading to the worsening pandemic handling. There are some evidence to support this argument, but firstly, we shall explain our conceptual foundations as we analyze the impact of COVID-19 in the Indonesian legal and political context. The first is the state of disorder, meaning that socio-political life is ordered by the logic of disorder, endemic corruption, no rule of law, pervasive legal uncertainties are not an obstructions, but instrument that facilitates two accumulations of power and wealth. In the legal context, this has created what we define as illiberal legalism, where the law works as an instrument of rule and serves the interests of wealth accumulations. Following the illiberal nature of Indonesia, we argue that the existence of democracy in Indonesia is accompanied by the absence of the rule of law. Here, rule of law refers to a set of rules that protect the citizens against arbitrary power that is close to liberal understandings in general. In post-authoritarian Indonesia, legal reforms have resulted in, among others, the establishment of new institutions like the anti-graft body, the Corruption Eradication Commission, or KPK, and the Constitutional Court. But recently, we see that both institutions show tendencies to be an extension of elite interests. The institutional design of KPK, for example, has removed many important investigation authorities through the revision of the KPK law. Within the context of disorder, there are more opportunities to produce problematic laws that contradict rational legal order. The 2020 mining law and the omnibus job creation law are the examples of how the state tends to facilitate rent-seeking interests. Here is some evidence that has been explained by existing studies. During the time frame of our analysis, the Indonesian government has created a mess with its handling of the outbreak and making the crisis even worse. And to illustrate the exploitation of a crisis through the misuse of the COVID-19 funds, we offered three notorious cases linked to the ruling elites. The first is the pre-employment card, or Kartu Prakerja. The second is food package procurement. And the third is the commercialization of vaccines. Another evidence is the issuance of contentious laws that was easily done during the pandemic, as the restrictions limited public protests. From this analysis, we came to a conclusion that Indonesia also follows the same path of other illiberal democracies that use the pandemic to silence oppositions and restrict political protests. This exploitation was made possible by the illiberal nature of political economic system under which political business elites are inclined to exploit the crisis for their personal gain. Instead of a problem, public health crisis has been seen as an opportunity to maximize the accumulations of power and wealth, which further deepens illiberalism in Indonesia. This means that Indonesia's poor handling of the COVID-19 pandemic is not simply a result of a lack of institutional capacity or coordinated efforts. It is because the government has little interest in seriously addressing the public health crisis caused by pandemic. I will end my presentation here, and I really welcome your questions, comments, and thank you.
Thanks very much, Rafika, for a wonderful presentation, albeit as all of the presentations are a bit depressing, but made much more lively by the beautiful street art that you included with that. So our next speaker is going to be Ricardo Salzad de Cunha, who is going to speak on Timor-Leste. Ricardo is from the University of Minho School of Law. Yes, if you'd like to start now, Ricardo. Thank you.
So thank you very much for the floor and for the opportunity to meet you again, albeit remotely. I hope that we can all meet in the near future in person. Thank you also for the opportunity to have taken part in this very interesting experience. Even though we are each looking into particular legal systems, the comparative lessons that we all take are also very, very interesting. Timor-Leste is a relatively small country, emerging still, probably the youngest from the 20th century. So the pandemic was also a challenge to the political system and to the institutions that were in place. We almost forget Timor-Leste has had presidential elections this year. We're in a election cycle that will end next year in the general election. So people have almost forgotten how challenging things were when the pandemic first hit. And they were in fact very challenging because at the time the first cases were reported, there was a political crisis also in Timor-Leste. The ruling coalition was basically dissolving. There was no agreement as to the approval of the state budget for the next year, and so there was a for 2020, and so there was a very important crisis ongoing. People were speaking of a change in the coalition, either that or early elections. So the prime minister at the time had presented his resignation to the president. The president did not accept his resignation. So the first order of business was to solve this problem, and so a new coalition came into place without the need for general elections. The government continued to be led by a junior partner in the coalition, which was also surprising, but it managed to adopt all the necessary measures. At the time, there was much discussion as to the legal, to the limitations of the government's powers to adopt the necessary measures, and so some of the measures adopted at the time now, again, as we look back, seem a bit odd, and at odds with what we have from that time, from that experience, also learned. At the time, the measures were very much indistinctive in nature. They were simply adopted given the urgency of the situation, lockdowns, also measures of individual lockdowns or quarantine measures or global lockdowns were adopted immediately. Economic measures, Timor-Leste was one of the countries that per person spent more on the economic recovery of the at the time it was not even recovery, it was to limit the economic effects of the restrictions, of the lockdowns. So there was COVID-19 fund set up in the budget, which also gave rise to some discussion over the measures for control, and especially parliament especially by the parliament. The paper I wrote at the time was called Life Under the New Normal of the State of Emergency. And this was because the discussion at the time was precisely what were the measures allowed by the Constitution for restricting or suspending fundamental rights such as freedom of movement by these measures adopted. At the time, the government attempted to legislate on the matter by way of what we call a decree law, but which is an executive measure, legal in nature, but still an executive measure, which attempted to limit, which attempted at first to implement an existing law, the law on health system, which somehow appeared to allow for an executive implementation, shall we say like this, by way of decree law. However, the president submitted this decree law to the Constitutional Court, to the Court of Appeal, which is the highest court in the land, for preventive constitutional control. And the fact is that the Constitutional Court decided that these executive measures limiting fundamental rights were unacceptable because only the parliament could do so, and under state of emergency. So the state of emergency was declared early in 2020. This was done relatively fast because it was also an urgent matter, and the proceedings were relatively fast. And the measures of the government were abandoned as such. Of course, that the implementation of the measures of state of emergency were also done by the government. So the end result was very similar. The government adopted installed the situation room and all measures necessary. Timor-Leste had a previous experience with the state of emergency and also state of siege in order to to contain the crisis of 2006, 2008, where there was some internal infighting between the armed forces and the police forces. So there was some experience on this matter. So this was also used for a different kind of fight. And so the successive renovation of state of emergency, of measures of state of emergency, led me to, at the time, to refer to my article here as the new normal under state of emergency, because in fact we were living a new normal under the state of emergency, and that was the how we were almost getting used to live with considerable restrictions, limitations to the fundamental rights, namely again freedom of movement and others. On the other hand, this was also a very interesting lesson as how to the separation of powers worked in a relatively new state. So, and because the government accepted the decision of the Constitutional Court, the Parliament and the President worked together first on overcoming the constitutional crisis, the political crisis, and then overcoming this constitutional crisis, which was not actually a crisis because it was easily overcome, and so the measures were adopted by the Parliament, declared by the President, implemented by the government. So that was also a very interesting lesson to be learned. However used to living under state of emergency we all became, the fact is that this order of affairs had to end at a given point, and so after the end of the measures on the declaration of the state of emergency, after it ended, and this is something that I would also like to contribute almost as an update to the present situation. The fact is that legislation was approved by the Parliament to allow for the implementation of some restrictive measures to fight some of the effects, residual effects of the pandemic still existing. So the possibility of determining, of imposing quarantine on individuals, namely traveling from abroad, suspicious cases. In some cases, even the discussion over the possibility of mandatory testing. Some of these measures were still discussed, and they were implemented again by a parliamentary law outside the state of emergency. So these measures were adopted outside the state of emergency. No longer a suspension of fundamental rights, but a restriction, what the Constitution refers to as a restriction of fundamental rights. Whereas the suspension in the state of emergency has a given regime, namely temporary, the restriction of fundamental rights has usually has no time frame. In this case, the fact is that the government opted for a mixed solution, because it adopted because it was the government that proposed to the Parliament, and the Parliament adopted, and the Parliament adopted a temporary restriction of fundamental rights. So it was a law with temporary effects. So it was a mixed solution. This temporary restriction of fundamental rights by way of a law of a Parliament was implemented by the government. this is still in place. This solution is still in place, and as of now and recently, the government has extended this legal regime until November 2022. So this is the current situation. Timor-Leste is a Portuguese-speaking country, part of the CPLP. It's a civil law system, semi-presidential, meaning that it shares many of the solutions with other Portuguese-speaking countries. And so this discussion has also happened in terms of comparative law. And the fact is that recently, a decision by the Portuguese Constitutional Court, which sometimes has irradiating effects into other Portuguese-speaking countries, and the other way around also. These discussions have been ongoing. But just to wrap up, this recent decision has decided that the measures such as individual quarantines or lockdowns would only be acceptable under state of emergency, meaning that ordinary legislation, even ordinary legislation by the parliament, could not restrict fundamental rights so intensively as to basically not allowing any possibility of enjoying them. So this is a decision that is in line with the suspicious of reinforcing the executive powers during state of emergency that exist during state of emergency outside the state of emergency. So it is also in line with the previous decision of the Court of Appeal of Timor-Leste. And again, it's full circle. It brings us back to the possibility of opened up by the courts that if this type of restrictions is only acceptable during a state of emergency, this is also an invitation for the parliament, presidents, all bodies of sovereignty to, when faced with these challenges, again, give us a new normal under the state of emergency. So again, full circle, we come to the title of this of the article that I was honored to present. So thank you for the opportunity, and I hope to. I'm also open to further this discussion in the debate. Thank you.
Thanks so much, Ricardo, and also for keeping to time perfectly there. And was very interesting too that you updated us on time since your article. So now it's my pleasure to introduce Robert Smith and Mark Perry, who are going to be talking on fake news in the pandemic in Southeast Asia. They're both from the University of New England, and Mark Perry will be the one who's speaking for both of them. So thank you very much, Mark.
So I have a few slides. As I always tell my students, the slides are there not so much for the enjoyment of the students, but to remind me to keep on track as to what I'm talking about. First of all, thanks to Helen and Catherine and Tim, and of course to Robert, and to the journal itself for publishing our article and giving us the opportunity to speak today. So also I should apologize for being a little late into the session. I didn't get in until about 4:10 because we had the New South Wales Law Society councillors and the presidents of regional New South Wales Law Society visiting the law school, and I had to go and wave the flag a little bit. So my own thoughts of COVID itself is that our societies, not just in Asia, of course, but of course across the world, have been severely influenced and changed in the way that governments deal with things, and and how we manage our societies. And some are a little bit more, how to say, dictatorial than others. But even here in Australia, we had a whole series of health orders coming out that both state and federal that we had to comply with. And there was very little discussion about the validity of these health orders, even though they severely limited the ability of individuals to take individual action on their own behalf. Anyway, that's another story. So we're talking really today here about fake news. And of course, this really is more than just COVID, but I think the two things really brought fake news into even the public view. The first perhaps was misinformation, or indeed deliberate disinformation around both elections and COVID and other areas such as hate speech in itself. So I'm just going to talk a little bit about that and what the stats are for Asian. It may be surprising to know that the impact or the penetrance of social media in Asian nations is extremely high. We didn't collect this data, of course, and the reference is in the paper. But the number of mobile connections in Indonesia, 345 million mobile connections is quite a lot of mobile connections, and it means that everybody pretty much can have access to online information, whether true or false. The star here is because, of course, Timor-Leste is not a member of ASEAN, although they have applied to become members. So the penetrance and the availability of ordinary folk in ASEAN nations is actually very high. And so the ability for people to be reached and misinformed as well as informed is also really high. So I just pulled out from our paper a couple of bits of misinformation or disinformation that were spread in a couple of nations. So, for example, in Indonesia, there were lots of hoax reports in Indonesia that Chinese police had been taking part in demonstration suppression. In Myanmar, there were a whole setup by the military there to create fake websites and fake information on places such as Facebook, portraying Rohingya as rapists and terrorists. And in the Philippines, of course, political opponents, journalists, Muslims, indigenous groups, and so forth had also been targeted by using blogs and websites and Facebook and YouTube to promulgate fake information. More, of course, you see, of course, in the US, they did a survey last decade in 2012, and the government there, and they found that around 5% of the population had serious mental illnesses. So it's not surprising, that's probably global, if you get people coming up with strange ideas. The point, I suppose, is that nowadays we can promulgate or disseminate those ideas across millions of people. And if you have enough of a hook, then people may be drawn in to believe the misinformation that you're spreading. So Facebook, of course, has been working after some pressure to counteract the fake information being posted by companies, for example, in Myanmar, Vietnam, and in other nations. And they found that it's not just individuals who may not be quite mentally secure, but also corporations and governments even have been using Facebook and other social media sites to spread information that simply wasn't true. So in the COVID realm, I suppose the problem is that not only is this information going to have the potential of inciting hatred, obviously not a good thing, having the wrong people elected to your parliaments because of beliefs about opposition, which are not true, clearly again a wrong thing, but also a widespread belief in fake information around vaccination, such as COVID being spread by towers, 5G towers for mobile networks, and so forth. This kind of fake information is also very dangerous and potentially extremely harmful to ordinary folk. So there have been across 18 countries a broad range of legislation that's been introduced over the last 5 years in particular. And sometimes it has been to target criminal repercussions for those who post misinformation or fake information. Usually it's under criminal legislation or criminal codes. Sometimes they're brought in specific legislation that seeks to prevent spreading things online. Criminal defamation, strange enough, is quite popular in Asian nations. But also you find in somewhere like Singapore, they have a very specific piece of legislation, protection of online falsehoods and manipulation. Others target communications and transmission, electronic transmission, and even trade legislation to bring in parts of that to try and suppress fake, at least that not supported by the government, fake news. So perhaps the key way to counteract fake data, whether it be on COVID or other things, is to have effective and well-supported and reliable fact-checking websites. So in Cambodia, for example, the Women's Media Center has cross-check, but of course then they, although have some support from Google and Facebook, who have at least come up somewhat to face these issues, but it's the NGO fact-checking certainly has a big impact, if people get to it and people use it, of attacking fake news. They face problems in many of these Asian states because, you know, many dialects are around the place, and if there's an unusual dialect that has fake news on it, then you have to find those in the fact checkers who speak that particular dialect or read it and then check it. And often that's quite hard to do. And in some places, the NGOs have been, you could say, persecuted, at least harassed by the government, suggesting that there's something wrong with their activities if they post anything that seems to be anti-government. The Singapore government has their own government-run site, Factually, which has, as well as an NGO that's quite good there, that supports fact-checking. So the upshot, I suppose, in the COVID realm is that if people if there's widespread belief of something like anti-vaccination, then that just simply allows the COVID virus to spread, mutate, and respread. So it becomes not just a local issue, but also a global issue. So if there's a single state or nation that allows such fake information to become widespread regarding, say, vaccination, then you'll find a multiplicity of new viral types coming out of that nation, because the virus has more chance to mutate if more people catch the virus. So this, of course, is a global problem, but certainly in particular with probably other aspects rather than COVID, the military and the governments in ASEAN have been very keen to use anti-fake legislation and anti-fake activities to suppress anti-government ideologies. So the problem, I suppose, particularly brought about was COVID, was that now, particularly, even now, I'm not sitting in my office at work, I'm sitting at home, as you may notice by the log fire, because it's cold here. The ability for people to go to work in many instances has been somewhat reduced, but for certainly office workers, the main form of communication now has become online, and there's been more reliance on online resources, and also the dilution of science. So as the previous speaker mentioned, so a lot of legislation and regulation was brought in ways that perhaps were not entirely within the boundaries of what was seen to be normal in the past, and that also in a sense was the case here, leading to a lot of confusion. So I'd just like to think about the future, and the future perhaps for maintaining truth, whether it be about health or other issues, is to perhaps place a greater burden on the social and media hubs to ensure that the information that they provide is indeed true and reliable, and that we support and use fact-checking organizations. And I just have a few here, which I suppose we rely on because they are known as reputable organizations. So, you know, the BBC or the ABC or the New York Times or the Edinburgh Public Policy Centre are not known as spreading fake information. Although, of course, the far right in the UK would say the BBC is left-wing, and the far left would say the BBC is right-wing. But those are, you know, extreme examples of pressure. In terms of getting health information out, you know, the government here in Australia relied primarily on television as a means of disseminating their thoughts, whereas in other countries, perhaps they have used other means. So that's just my brief thought. And my own thought is that, you know, COVID has indeed changed all of our societies, and how they've changed is not going to become very clear until some time passes and we can reflect. So I think I've run out of time. I'm sorry, I'm a bit rambly. I've talked to you all questions now, or feel free to find me and send me an email.
Thanks very much, Mark, for that. And we'll now go to questions. And in fact, Mark has very kindly set us off with our first question. So Mark would like to ask Rafika if the government really doesn't see a pressing need, even from a purely national economic basis, rather than a humanitarian one, to mitigate the effect of COVID on the general populace. So Rafika.
Thank you, Helen. Thank you for your question, Mark. Yes, it is our argument is that it is so obvious that the Indonesian government is more concerned with facilitating rent-seeking interests than with containing the virus. So we provide the evidence for this argument in the section about Indonesia's messy handling of the COVID-19 pandemic. And I should underline here on the rent-seeking interests. So the government might claim that they are prioritizing national economy. For example, here by attracting more tourists in early 2020, even though other neighboring countries already declare that the virus has been entering their country, or by allocating special budget, but not for specifically addressing the pandemic, but to recover the economy. But who are benefited from these policies? Is it national economy? Economic contraction is not that bad, yes, compared to other Southeast Asian countries, but who are most benefited from them? And to answer these questions, we can see who are facilitated by the issuance of many contentious laws, especially the mining law and the omnibus job creation law. And those are political business actors that who close to the president. We can also refer to the case of corruption of social aid fund, Bansos, for Kovid by a minister from the ruling party, PDIP. Many believe that money that is supposed to be delivered to the poor to be able to survive from the pandemic are corrupted for political machinery of the ruling party. And even in attempt to prioritize what the government claims as productive national economy, it was done not by containing the virus, but by sidelining it. So when vaccines has been globally distributed, the government even still tried to commercialize them first. So I would say, yes, this is the bitter truth. Thank you.
Thank you, Rafika, for that sad response. Now, I've looked in the Q&A and there aren't any questions there. I assume that if somebody had a burning issue, you would have put it there, and we've just about reached our time for finishing. But before I thank everybody, I'd just like to make two comments to reiterate what Tim said, that the Australian Journal of Asian Law is currently preparing for a special issue on the death penalty. So if anybody would like to contact us to suggest either that they or someone they know would be suitable, we'd be very happy to hear from you. The second comment that I wanted to make is on the program that was on, that you clicked through. For those who didn't notice, if you run your browser across the title and press, it will actually lead you through to the article by the author. So I'd recommend that if someone particularly appealed to you and you want to read more about them, that's an easy way to find it. The Australian Journal of Asian Law, to access the articles, you do need to become a member of SSRN, but this is free of charge. So don't be frightened if they say you need to become a member. So yes, you can obtain all of those articles free of charge and read more from our wonderful speakers. So now I'd like to thank, first I'd like to thank Ju Chong for being the guest editor on this issue, and it was wonderful working with you. And secondly, I'd like to thank all of the speakers who, of course, were the authors for the issue, and we spent a long time together during the writing, and I feel I got to know everyone, even those in different countries. So it was a delight to work with you all, and a delight to have you speaking today with us. I'd also like, as Tim did, particularly to thank Catherine Taylor, who was the force behind this seminar, and without Catherine pressing all the right buttons, none of us would be able to speak to each other. So thank you very much, Catherine, for all the work that you've done behind the scenes. And finally, I'd like to thank everybody who took the time to attend in a virtual way. It's been wonderful to have you. Unfortunately, with these online things, we can't see you, but we still think of you, and we can see the number who are attending down there. So thank you very much for attending this seminar. And now, Tim, would you like to say the final word?
Just to reiterate your thanks, but to say that the Australian Journal of Asian Law is really the only journal of its kind that publishes broadly on domestic laws in countries rather than international and comparative. And we're well into over 2 decades now since we were set up. And we look forward very much to continuing to build the network of contributors, but also reviewers. And we're always looking for people who are willing to referee and review the articles we receive. So we might be back in contact with all you authors again to ask you to be reviewers. So be ready for that. But thank you again for everything you do for us. And we look forward to working with you in the future.
So thank you, everyone.
Thank you, everyone.